Good afternoon, everyone, and thank you for joining this lunchtime talk on Tindall and Chief Constable of Thames Valley Police. My name is Celia Reynolds, and I'm a second-year tenant at 39 Essex Chambers, and I'm joined today by Scarlett Milligan.
Hi, everyone. Thank you for joining us.
A reminder to please ask questions throughout today's presentation. There should be a Q&A box contained on the bottom part of this Zoom presentation. We will try to address your questions at the end. Also, we will be making reference to a variety of authorities throughout this talk. We don't intend to provide their full citation while we're speaking, but we will provide a list of those authorities after today's discussion. Now, before we begin unpicking the naughty principles of this case, Scarlett is going to give a quick overview of the facts which the court was confronted with in Tindall.
Yes, so it's probably important to say at the outset that the facts were either agreed or they're being assumed, because this appeal arises out of a strikeout and a summary judgment application. And so for the purposes of a strikeout, the court's always going to consider taking effectively the pleaded cases at its highest and assuming that if you were to go to trial that those facts will be proven. But so on that basis, it was the widow of Mr. Tindall bringing a claim against Thames Valley Police. Mr. Tindall was driving southbound on an A road, a single carriageway, when a car on the other side of the road going northbound effectively lost control on some black ice and crossed over into the path of Mr. Tindall, causing a head-on collision. And sadly, both the drivers died. A case was brought against Thames Valley Police because on that very same stretch of A Road, some 184 metres away to be precise, the police had attended approximately half an hour earlier because Mr. Kendall, a third party, had slipped, effectively his car had slipped on the ice and had gone off into a ditch on the road. He wasn't seriously injured, thankfully, but he called the police to let them know that this was an issue, and the police then attended. When the police attended, they put out a police slow sign on the other side of the road, and obviously there were their blue lights indicating their presence. They were also joined by the fire brigade and eventually an ambulance. When Mr. Kendall was taken by ambulance to hospital, the police left shortly thereafter, taking away that police fire sign, and the fire crew left. And as I say, it was about 20 or 30 minutes later when the fatal crash happened. And there was a 5-week inquest. The jury found that more could have been done, things like placing signs there, staying at the scene until gritters arrived, because one of the officers had put in a call for gritters, but not expressed any sort of timescale or urgency in which they were needed, and more support could have been done. So that was the findings of the inquest. There were also police disciplinary proceedings resulting in findings of misconduct and gross misconduct against the officers, and that set the scene for the claim in common law negligence against Thames Valley Police. I should probably say here, Celia, if you don't mind, just a bit of a brief intro as to what was decided at first instance and how it went its way up to the Supreme Court. So it was pleaded that by the police effectively removing Mr. Kendall from the scene and taking control of the road, that the police had taken a positive step, they'd assumed responsibility for the scene, and they effectively were negligent in doing so. Master MacLeod at first instance didn't strike out or give summary judgment. She noted that the area of law, whether or not a duty of care arises, whether things are acts or omissions, was an area of law that was in a state of flux. It was highly fact dependent. The case then went up to the Court of Appeal with Thames Valley Police appealing, where they were successful. They successfully argued that the law was not in a state of flux. It was settled. And in a unanimous judgment given by Lord Justice Stuart Smith, the Court of Appeal said this is a paradigm example of a public authority responding ineffectually and failing to confer a benefit. So there's no arguable case of a positive act or an assumption of responsibility. And the judgment ended specifically saying the law is not in a state of flux. On the contrary, the law is settled by successive decisions that are binding on this court. And so the claimant appeals to the Supreme Court.
And I think it's worth, before we dive straight into the Supreme Court decision, just to take stock for a moment between, on the basis of what we mean when we refer to positive steps and acts and omissions, failure to confer a benefit. All of this is important because, as many of you will already be aware, negligence draws a distinction between positive acts, which in principle a claimant can recover, and omissions, where the general rule is that the claimant cannot. Case law sometimes refers to a rescuer principle. So the idea that if a passerby sees a person drowning and does not go to help them, they cannot be held negligent for failing to step in. But if that passerby, say, for example, throws something down to help them, which hits their head and causes them to lose consciousness, that person should be held liable in negligence. Another classic example is capital and counties, where the fire brigade arrived and turned off the sprinkler system, which was managing the fire at a property, which obviously caused the fire to spread and cause more damage than would not have otherwise occurred. Now, over time, the court has developed a variety of exceptions to this presumption against omissions being giving rise to a claim. We could do a whole webinar on that. It is a complicated and complex area of law, but in very brief outline, there's sort of three which we see here. Firstly, where a tortfeasor has a special level of control over the source of danger. A classic example being the Dorset yacht case, where a group of young offenders escaped from an institution and caused damage to 2 yachts. That institution was held liable in negligence because they had control over those offenders. The second being where a tortfeasor has done something which prevents another from stepping in to protect against a danger. For example, the redirection of emergency services, although that point can be difficult to apply in practice. Thirdly, where the tortfeasor assumes responsibility to protect the claimant from danger. For example, the police telling a caller to stay put because there'll be a few moments, but not actually arriving, and then harm accordingly arises. The claimant in Tindall argued these exceptions as an alternative case. For example, that the police had assumed responsibility over the road, that they had a special level of control of the danger for the ice as well.
And I think it's important to ask ourselves, why are we having a flurry of these cases? We've seen many cases coming up all the way to the Supreme Courts in recent years, dealing with the issue of acts and omissions and public authority liability. And that is because, generally speaking, there has been a shift over the last decade or so from the approach that might previously have been described as somewhat akin to blanket immunity for these emergency services, first responders. So the notion that individuals like police officers, firefighters, ambulance staff shouldn't be held liable in negligence for policy reasons, because of resources, because the time, energy and resources needs to be spent looking at and looking after those that they respond to, rather than dealing with the precise minutiae of their actions and whether or not that would lead to claims of negligence. Whereas previously, that might have effectively worked in stopping a claim in negligence. The more widely held position now is that actually there's no distinction between a public authority and a private individual when one is looking at negligence. So that's gone up to the Supreme Court in numerous cases: Michael, Robinson, Enenpool, HXA. As Celia said, all of these will be listed on our website once the webinar's finished. But so despite those serious numbers of authorities going all the way up in such a short period of time, the claimant in Tindall still argued effectively, or well, because of the special status of police, they should be able to they should have this duty. And I think it's worth just saying that that's put to bed, and the emphasis and the focus on positive acts versus omissions is so important now because it's up for grabs for public authorities.
Exactly. And in all those cases which Scarlett has mentioned, the court had in effect been tasked with trying to decide whether what was complained of was in principle an act or an omission. But in Tindall, which I think is important to emphasize, the Supreme Court observed that drawing that distinction is not always that straightforward. Rather, the more recent language which has been used in those cases between making matters worse and failing to confer a benefit was actually far more illuminating. We agree, as opposed to getting bogged down into what is an act or an omission, which can be quite nebulous, it's helpful to focus instead on precisely what the defendant has done. We think it's quite helpful to read in particular paragraph 44 of the judgment, where the court provides a helpful summary of the law in this area and draws out 5 central principles, which I'll go over now. Firstly, as I've just said, the distinction is to be drawn between failing to confer a benefit, which is not recoverable, and making matters worse, which is recoverable. Secondly, many of the cases which the court had discussed prior weren't actually about omissions at all, but positive acts by emergency services. A classic example is Robinson, where police officers were in the process of apprehending an offender, and in the process of enacting that arrest, knocked over an elderly lady. So that was plainly a positive act, which the police were then held responsible for. Thirdly, the central difficulty in this case, the Supreme Court observed, was how to identify the baseline relative to which one judges whether the defendant has made matters worse. Here, the judgment underscored, and I'm quoting here, that the relevant comparison is with what would have happened if the defendant had done nothing at all and had never embarked on the activity which had given rise to the claim, and then with what actually happened. Fourthly, another way to consider the general rule here is that public authorities owe a duty not to expose others to unreasonable and reasonably foreseeable risks from their own conduct. So again, if we think of Robinson, the police officers knocking over an elderly woman while in the process of arresting someone. However, there's no general duty to protect parties from risks that arise independently, whether that's from a natural cause or from another third party. Finally, the court also reaffirmed that the exceptions to the general rule still exist, for example, where there's an assumption of responsibility, which I discussed earlier. So in summary, it is only if carrying out a positive act that makes the claimant worse off than if the activity had not been undertaken can liability actually arise. However, there is a particular difficulty in understanding how to apply these issues, where what is alleged, as in Tindall, that the positive act is in essence the preventing or putting off of others who would have rescued or taken steps to help. The Supreme Court then recognizes this principle of the intervener, which Scarlett will talk us through now.
Yes, so it's variously referred to as the intervener or the interference principle, and the notion is that the steps that the tortfeasor has taken, in this case, removing Mr. Kendall from the scene, prevents this third party, as between the tortfeasor and the claimant, from taking steps that would either prevent or mitigate the harm. So in the case of Tindall, Mr. Kendall had given a witness statement, and so it was assumed it would be proven at trial, saying that had the police not sort of come along, called an ambulance, popped him in the ambulance, and off he went, had that not happened, he would have remained at the scene and he would have been continuing, as he was before he made his call to police, to wave down vehicles, trying to get them to either stop or to slow down, to generally alert them. And so the argument was that actually it would have been better had the police not turned up. How did the court look at this? Well, the court went through a lot of the case law, as Celia's already made reference to. It's a really helpful judgment for just taking stock of where we are and how the cases have progressed over the years. In Tindall, the Supreme Court said, and it was a unanimous judgment given by Lord Legate and Lord Burrows, said that effectively they could accept that the police officer's actions did in fact put off or prevent Mr. Kendall from taking steps to help other road users. And as Celia said, this has been described in the judgment as the interference principle. That's something that the judgment takes from a book by Nicholas McBride and Roderick Bagshaw. And the court looked at this and said, actually, it can help us understand, although it's not referenced in the reasoning of any other cases to date, it's a good statement of English law, and it helps us understand how some of the cases have been decided. So, for example, there are two earlier cases where the court suggested this was in fact what was happening, the application of the interference principle. And that one was Kent and Griffiths, which is a Court of Appeal case from 2001, where the claimant was suffering an asthma attack. 999 was called. The ambulance didn't show. People at the scene kept calling back, and each time the ambulance or call operator said the ambulance will be there in a few minutes. But in the end, the ambulance took 30 minutes to arrive. And because of that delay, the claimant had a respiratory arrest and suffered brain damage. And the Court of Appeal found that effectively this was the provision of wrong information by the call handler, and that but for that misleading information, somebody at the scene would have driven the claimant to hospital, taking steps to protect her or prevent the harm. And she would have arrived before the respiratory arrest. A similar case also involving the healthcare services is Darnley and Croydon NHS Trust. This is a more recent 2018 case in the Supreme Court where the claimant went to A&E with a head injury, was told by the receptionist that the wait will be 4 to 5 hours, and thought, no, thank you, and decided to leave, when in fact, the claimant would have been seen within 30 minutes by a triage nurse who would then decide, based on symptoms, how quickly he needed to be seen. And at home, the claimant collapsed. An ambulance was called, but sadly, the claimant suffered permanent brain damage. And in both of those cases, the Supreme Court has now told us it's the provision of misleading information that puts people off, the intervener off, from taking steps to prevent or mitigate against harm. And that's why we distinguish these cases from, for example, the case of Michael that Celia's referred to, the 2015 Supreme Court case, where on the telephone, a woman called and said, my former partner has said he's going to come and kill me. And the police control or call operator simply said words to the effect of, that information will be passed on. The operator didn't say, stay where you are, we'll be there in 10 minutes, for example. And so it's looking at whether or not it's that active provision of misleading information or something else that puts someone off assisting. Now, the Supreme Court's judgment, as I say, recognises this for the first time as a statement of English law, but says that it in any event follows from first principles. And they looked at the case of capital and counties, which Celia has already walked us through, and they said it's analogous because it doesn't matter whether you're turning off an object or getting rid of an object that can prevent or mitigate for the harm, in that case, the sprinklers, turning them off, or whether it's a person. There's no real reason why there should be a distinction there between the two. And so as I say, the Supreme Court said that this in principle could arise on the facts of Tindall, but they made it very clear that what is absolutely pivotal when you're applying this principle is that the tortfeasor must have known or reasonably to have known that their actions would reasonably have or might have the effect of putting the intervener off or preventing the object from working, or as it would, etc. Because that's pivotal, as we'll see on the facts of Tindall, because it's essential for these people to know that their acts are going to have these consequences in order to be liable. Otherwise, you can see how widespread liability may occur when, in any case, it said that, well, I was about to do this, or X was about to arrive on the scene and do Y, and that would lead to really quite broad principles of liability. So, Celia, do you want to tell us a little bit more about how the application of acts and omissions and actually the interference principle came about on this case?
Of course, thanks, Scarlett. So on the overarching question of whether the police made matters worse or failed to confer a benefit, at paragraph 60, the court accepted that based on the pleaded case, the attendance of the police had caused Mr. Tindall to stop attempts that otherwise would have alerted other motorists to the existence of a danger on the road. And on that pleading, the case was, in principle, possibly fell within the interference principle. For reasons that Scarlett has just outlined, the court considered it vital what the police knew or ought to have known about Mr. Tindall's warning efforts. But on that basis, there was quite a significant and serious factual lacuna within the case that was ultimately fatal to the application of the interference principle. There wasn't a pleaded allegation that the police were aware that Mr. Tindall had done any of that, or any basis for saying that the call handler or the police knew that he had stated an intention or had been in the process of making attempts to alert other motorists to the ice that was on the road. Effectively, as far as the police were concerned, they knew about a victim who had an accident, and they didn't know that he was actually acting or intended to act as a rescuer. Nothing gave rise to this knowledge, actual or constructive, that Mr. Tindall would have, but for leaving the scene, continued to take steps to protect road users from harm. So in the absence of any positive act giving rise to liability, the court then turned to those exceptions which I previously outlined, and they observed, firstly, that the police obviously hadn't created the danger of the ice in the road, so this was sort of a natural phenomenon. Secondly, that the police had not actually exercised any control over the area of the road. They did not cordon it off or close the road. And the site of Mr. Tindall's fatal accident, which eventually occurred, was actually 186 meters from where Mr. Tindall had been. And so was clearly some distance from the scene. And on that point in particular, the court reminded us that the police simply turning up and turning on your blue lights cannot of itself give rise to a liability, even if the police's arrival will give motorists cause to, say, slow down their vehicles. Thirdly, given that there was no exercise of control over the road, there obviously couldn't be an assumption of responsibility. The public authorities did not say or do anything which gave Mr. Tindall or other motorists reason to rely on their presence. And on that basis said, we find it impossible to see in these circumstances how an assumption of responsibility could be said to arise. That point wasn't actually pursued by the claimants in the Court of Appeal, but the court does deal with it. Finally, the court also rejected the status exception, which Scarlett had spoken about before. Again, the case of Michael, as Scarlett has discussed, laid it plain that there is no special duty on the part of emergency responders to keep particular individuals safe. So, Scarlett, if you could then just remind us on what this case leaves us with.
Yes. So, well, before I do, Celia, I think it's one thing I omitted to mention earlier when I was talking about the interference principle was one of the cases that the court overturned or well, it said it was wrongly decided, because as I say, the judgment is a very full analysis of when and why public authorities might be liable in tort. And in one case, the case of OLL against the Transport Secretary, it's a first instance High Court case from 1997. The Coast Guard misdirected the Royal Navy to an area of the sea where a canoe had gotten into difficulties. The Royal Navy was eventually able to locate them and respond, but later 4 of the children on the canoe died from hypothermia, and there was effectively a claim for the delay caused by that misdirection. And the way that the judge in that case approached things at first instance was to say, um, although it was argued that this is what is analogous to capital and counties, the turning off of the sprinklers, the court said no, because it would be artificial to distinguish between the Coast Guard directing its own rescuers to go to the canoe and just directing another public authority. And the court said that would be quite artificial to find you would be liable in one instance but not the other. Now, in the unanimous judgment given by Lord Burrows and Lord Leggett, they said, no, we don't agree. It's not an artificial distinction because the Royal Navy are a completely different entity. They've got different legal responsibilities. So they're just because they're a public authority, there isn't any sort of special rule that somehow changes the situation compared to, say, if the Coast Guard had misdirected a private individual. A la Michaels, a la Robinson, there is no distinction. We are just applying the plain principles in negligence. So the court said that they thought that was wrongly decided and that in that case, the Coast Guard ought to have been held liable. So again, I'd recommend for anyone who regularly deals with, or even for the first time is dealing with a claim, to go through the judgment and to understand how all of this case law builds a picture, because sometimes when we're dealing with claims, you can see some people will pick one case where there's been an authority in a particular wording in the judgment has been relied upon, but actually when you take that step back and you look at things holistically, the picture's slightly different. It's been changing over the years. So with Celia's excellent summary of the principles and how they were applied in the case of Tindall, we have identified 4 key takeaway tips for what you can do when you're either bringing or defending claims that involve the acts or omissions of public authorities. There are many more, but we'll inevitably run out of time. We're going to try and keep a little bit of time left to answer your questions, so keep them coming in. The first tip is, at the very outset of your claim, have in mind the general rule and let it be your guiding principle. Has the public authority, made matters worse or failed to confer a benefit by acting ineffectually or not at all? So when you're drafting a claim or you're first receiving one and thinking about the defense, leave aside what's pleaded, leave aside what the jury have said in an inquest or in whoever else has said what in other proceedings, and just think at the heart of it, is this making matters worse, or is it failing to do anything really when we might expect them to have? So that's your guiding principle, number 1. Number 2 is to think very carefully at an early stage in the claim or your defense about the evidence in respect of any allegation of effectively the intervener principle. Because of this prevented X from attending and helping, or Y doing something, or this object from assisting me. And it's important because there are likely to be, as there were in this case and many of the other appellate cases, applications for strikeout for summary judgment at an early stage before, for example, the disclosure of evidence, before the exchange of witness statements. And so if your facts aren't in your pleadings, you're leaving an important hole, or as Celia said, a factual laguna, which entitles the defendant to come along and say, right, well, there's no pleaded element of why the intervener principle arises on this case. So if you're bringing a claim, make sure that your pleaded case sets out why the public authority knew, or reasonably ought to know, constructive knowledge, that their positive acts would put off a third party from taking preventative or protective measures. On the flip side, if you're defending and you get a claim, check whether this essential ingredient forms part of the pleaded case. That is, we think, likely to cause a greater degree of work up front, because it means you're having to go through the evidence and effectively take a witness statement, at least in principle, from this third party, and perhaps even doing some digging around the how things would have played out had they been involved, before you settle your pleading. Connected to that is our takeaway tip number 3, which is consider, if you're defending, bringing a strikeout application early, because this case and the other appellate and Supreme Court authorities indicate that can be quite a successful way to get rid of these cases early without causing unnecessary cost and time. It's worth saying that in Tindall, you'll remember at the outset that I said that Master MacLeod at first instance had said, well, the law is in a state of flux here. There's been a lot of developments, and so it's probably not appropriate to strike it out. I'll let things play out to trial. By the time that this came to the Supreme Court, and the Supreme Court identified, as Celia said, the factual laguna, there's nothing to show why the police would know Mr. Kendall would take those steps. It was argued before them that, well, because of the development of this area of law, have a look at all of this wealth of authority that says strikeout really shouldn't be applied in a case where there's been developments in the law. Strikeout shouldn't be based on hypotheticals. They should be based on sort of actual principles, and where those have been developing, it's inappropriate to strike out before trial. Let's wait and see how trial plays out with all of the knowledge and what is said during the trial about knowledge. And the Supreme Court held, and it's paragraph 68, I'd recommend pulling it up if you have the time, that it may have once been the case that this area was in a state of flux, but that it certainly no longer was, particularly since the cases of Michael and Robinson. Now, there is an argument that feels a little bit harsh in circumstances where the cases spent 4 years going up to the highest appellate court, and it also recognises a new statement of English law that hadn't ever been set out in those terms in a previous case. But irrespective of what one thinks as to its harshness, that what you can see is that it's going to be very unlikely now, particularly in a post-Tindall world, that you will be successful in arguing, oh, well, this is all very developing and it's all very complex. Never mind my pleading, let's just see how things turn out at trial. I think you need to prepare for that to be rejected. And so equally, if you're on the flip side, you probably have quite good grounds for bringing strikeout and summary judgment applications if that essential ingredient is missing from the claim. Our 4th tip is probably one that's somewhat applicable for all of good practice. But we would say, given what we've said about the need to do that earlier bit of work and take protective steps to ensure that your pleading is bulletproof, if I can put it that way, it is probably best in these kind of cases not to leave one's pleading and bringing of the claim till the last minute. it is likely that further investigations may be needed. And furthermore, if, and let's hope this isn't the case, as things are progressing, and you identify that perhaps your pleaded case isn't robust as it could be on these essential elements of foresight or constructive knowledge, you'd really much rather be making an application to amend your pleading before limitation has expired. Whereas if you've issued just before, you've then got that additional hurdle of saying to the court, we would like to apply and we would like to do so after limitation. So those are our four key takeaway tips. We've got just a couple of minutes to answer any questions. Somebody has asked the question, would the outcome in Tindall have been different if the scene was the same rather than 186 meters away? Well, my view is that on the applying the intervener principle, I think the analysis would be the same. There's nothing to do with the distance that gives rise to the police having knowledge or constructive knowledge that Mr. Kendall would have acted in the way that he did. The distance was more relevant in Tindall on the question of the assumption of responsibility. So the court's analysis is slightly short on assumption of responsibility because effectively the point was abandoned during the oral hearing before the Supreme Court. But what the Supreme Court do say is that they see it's difficult to see how an assumption of responsibility would arise because there is nothing that the police would have communicated to Mr. Tindall or to any other road user upon which they could rely to say here was an assumption of responsibility for my safety on this A road. And I think that the reasoning that Celia has mentioned about blue lights not being sufficient, it's not like they didn't close the road, they didn't cordon it off, all of that would have been applicable, even if it was this exact spot where Mr. Kendall was. Those are my views, Celia. I don't know if you disagree or have anything to add.
No, I think that's right. Although I do think it's interesting to consider that, you know, if there had been pleaded evidence in this case and there hadn't been that factual lacuna, for example, and they had actually addressed, what did the police know? Say, for example, there was evidence of the responders having knowledge that he had been redirecting motorists. I think actually that might have had a significant impact in this case. I don't know what you think, Scarlett, but it seems to me that seems to be the key point here where this case is falling down. And then it is interesting that the exceptions, if you read the judgment, aren't actually dealt with in as much detail. So I think there is, at least it's beneficial for claimants here, that there is a greater degree of guidance as to what is expected in cases like this, as Scarlett has outlined.
I agree. And I think your observation that it would have been interesting if we had seen something pleaded as to why the police ought to have had that knowledge, it would have been interesting to see to what degree of specificity is the court expecting that constructive knowledge to arise before they ought to have effectively they'd taken a step and they made things worse. And I think for any new claims, this is probably going to be the new battleground. I think that you can see it's one thing to say the police or any other first responder had actual knowledge where, for example, let's say Mr. Kendall was another person had pulled over to check he was okay, and that they overheard the police officer calling for a gritter. And let's say that they said to the police, I'm not in a rush. I can stay put if you like until the gritters get here. Appreciate you've got a lot on. And if the police said, no, don't worry, you just go home, that might be said that they've taken steps to stop an intervener from taking protective measures, and they knew that he or she was going to do that. I think the battleground, as I say, is constructive knowledge and the argument of, well, you didn't actually know that I or somebody else was going to take these protective steps, but you should have. And would that involve, on the facts of the Tindall case, Mr. Kendall, for example, when the police pulled up, if he's start flagging down cars, is that what required? What about on the transcript of the call with the operator, the minutiae of which is not necessarily going to be passed on to the officers actually responding at the scene? What if, for example, there is something there saying, I've flagged and I don't mind flagging other people down just to make sure that they're all right. So there are all of these nuts and bolts that will need to be worked through, but I can see that being, as I say, a source of a good legal fight for another day.
Exactly, I think that's right. Well, I do think that's everything. And so I'm just going to take a moment, I suppose, to thank Scarlett for joining me on this talk and providing such useful tips. And thank you everyone else, obviously, for joining in today. We are available and we will try to answer the questions asked by email now. Also a reminder that a recording of this talk will be made available, although it'll probably take roughly about 2 working days. But thank you again. And have a lovely rest of your day.
Thanks, everyone. Good afternoon.